Chapter 4, Section 11. Social Movements. Government Response. Social movements pressure the government to make changes based on movement goals, but the process by which movements successfully change laws or win court cases is complex. Movements must work to create a social and political atmosphere in which laws can be passed and supported by policymakers, even if some of their constituents may not be enthusiastic. Often, movements must work to change older laws or constitutional understandings before moving on to their larger goals. Examples of this process can be seen in the Civil Rights Movement. The movement pursued a multi-pronged strategy, simultaneously working to change social attitudes and educate the public while advancing legal challenges to discriminatory laws and practices, and pressuring lawmakers to support new laws that furthered movement goals. Cases like Brown and laws like the Voting Rights Act of 1965 are examples. None of these changes happens fast, typically. Plessy v. Ferguson was decided in 1896. Movement leaders continued to challenge this precedent in the intervening decades, but it wasn't until the 1950s, as the Cold War advanced and political calculations changed, that they had success at the Supreme Court with Brown and its companion cases. It wasn't until the 1960s, after successful efforts to educate people about the effects of segregation in the South, that the movement was able to get new laws passed to protect civil rights. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 were supported by people who overcame internal divisions to push for a common goal. These laws touched on the goals of multiple movements, such as the Civil Rights Movement and the Women's Rights Movement. For example, Title VII of the Civil Rights Act prohibited sex discrimination in public accommodations. The Women's Rights Movement won another victory when it pressured President Nixon to sign the Education Amendments of 1972, which made Title IX law. Title IX prohibits sex discrimination in education. Usually, the government is reactive on civil rights questions, waiting until it is pressured to act. The judicial branch is passive in the sense that cases must be brought by aggrieved parties. The courts cannot identify issues and reach out on their own. Consequentially, social change generally happens before the legal change, though the two are related. Law shapes society, and society shapes law. Sometimes laws are merely codify social agreement, but at other times a law advances rights beyond popular conceptions. This was the case with Brown, a decision that was very controversial at the time. In creating an independent judiciary, the founders wanted to give the nation the capability of upholding the rights of minorities despite majority resistance. Typically, a court makes a decision, or a legislative body passes a law, that reflects the prevailing thinking at the time. People either agree or disagree with the decision or law, and as time passes, public dialogue creates opportunities for movement supporters to organize and persuade others to change their minds on a given issue. After social and political shifts take place and legal understandings change, a court considers a law or decision again, sometimes affirming its previous decision and sometimes reversing itself. In this way, the law both forms and adapts to changing social values.